Good morning, students. Let's continue with our fundamental rights. Chapter 2, Rights in the Indian Constitution. In our last class, we have discussed right to liberty and personal freedoms and right to freedom of religion, right against exploitation also. Today we will discuss cultural and educational rights of minority groups. What do you mean by cultural and educational right? Why this is made our fundamental right? Is there any need to make cultural and educational right a fundamental right? So, we will discuss here what is the necessity to make this right fundamental and what purpose it solves. Indian society is full of diversity. Here different religion, people of different religion, different caste, different social and cultural background, different linguistic group live together. We are a society that has vast diversity. In such a diverse society, there would be social sections which are small in numbers compared to some other groups. There must be some large group and there must be some small group also. If a group is small or if a group is in minority, will it have to adopt the culture of the majority? What do you think? The group which are in minority have to adopt the majority's culture? Obviously, the answer is no. Our constitution believes that diversity is our strength. Therefore, one of the fundamental right is the right of the minority to maintain their culture. This minority status is not dependent only upon religion, but linguistic and cultural minorities are also included in this provision. Means the people having religious minority, linguistic minority or cultural minority includes in this provision. Minorities are groups that have common language or religion and in a particular part of the country or in the country as a whole. They are outnumbered by some other social sections. Such communities have a culture, language, and a script of their own and have the right to conserve and develop these. Only this right can give the minority people a space of their own and a chance to develop freely. All minority religion or linguistic group can set up their own educational institution, and by doing so they can preserve and develop their own culture. The government will not discriminate against any educational institution while granting aid to the educational institution. Means government will treat all the cultural or minority groups equally. And this is the beauty of our democracy. We are practicing democracy in right way because here all the persons have equal rights. Now the next right is right to constitutional remedies. We have seen that our constitution contains a very impressive list of fundamental rights. But merely writing down a list of rights is not enough. There has to be a way through which they could be realized in practice and defended against any attack on these rights. Right to constitutional remedies is the means through which this is to be achieved. Dr. Ambedkar considered the right to constitutional remedies as heart and soul of the Constitution because this right gives a citizen the right to approach High Court or Supreme Court or get any of the fundamental right restored in case of their violation. Means by the right to constitutional remedies, anyone can approach High Court or Supreme Court if their rights are violated by anyone. The Supreme Court and the High Courts can issue order and give directives to the government for the enforcement of right. So by this right, any person whose right is being violated can approach to the court, approach to the judiciary, and judiciary will take action by issuing some order. Now here we will see what type of special order, what type of order court can issue. The court can issue various special order which are called writs. So what is writ? Writ is a special order of court that court issue for the enforcement of someone's right. Now these writs are of 5 types: Habeas Corpus, Mandamus, Prohibition, Quo Warranto, and Certiorari. These are the 5 writs by which court order the government or any person who is violating others' right and to enforce the right. So first is Habeas Corpus. A writ of Habeas Corpus means present the body before court present the person before court. Means, by habeas corpus writ, the court orders that the arrested person should be presented before it. If a person is illegally arrested or illegally detained, so his right to freedom is violated, and his family member may go to court for enforcement of his right to freedom or freedom of life, and then court will order to produce that arrested person before it. It can also order to set free an arrested person if the manner or ground of arrest are not lawful or satisfactory. If the arrest is made illegally, or the procedure is not properly adopted, then court can order to set free that arrested person. This is writ of habeas corpus. The second writ is Mandamus. This writ is issued when the court finds that a particular office holder is not doing legal duty and thereby is infringing on the rights of an individual. Now suppose a government officer sitting on his table, he is authorized to do his duty, but if he is not doing his duty properly, and for that someone's fundamental right is being violated, then that person can go to court, and court will order that particular office holder to do his legal duty properly. Now, the third writ is prohibition. This writ is issued by a higher court, means High Court or Supreme Court, to the lower court. When a lower court has considered a case going beyond its jurisdiction, then High Court or Supreme Court order the writ of prohibition to the lower court. The next writ is quo warranto. If the court finds that a person is holding office but is not entitled to hold that office, then it issues the writ of quo warranto and restrict that person from acting as an office holder. Means, in quo warranto writ, if court finds that a person is doing any work in the capacity of that post for which he is not capable, for which he is not authorized, and sitting on the unauthorized post, he is doing some work that infringes someone's fundamental right, then court can issue this writ person from acting as an office holder. Then comes writ of certiorari. Under this writ, the court orders a lower court or any other authority to transfer a matter pending before it to the higher authority or higher court. Means if someone's case is pending before any district court and plaintiff or complainant thinks that his or her case will be not properly taken by that court, then he can approach High Court or Supreme Court, and court will issue the writ of certiorari to that lower court and order it to transfer the matter to another court or before the higher court. So these are our fundamental rights. Hope you all understood very well. Go through your book, and if there is any query, feel free to ask. In next class, we will take other topic, that is directive principles of state policy. So enough for today. Thank you.